LiSTNR production.
Hours after Celeste Manno posted a photo online with her new boyfriend, she was dead, stabbed to death in her bed. Luay Seiko scaled a fence and broke into Celeste's suburban Melbourne house in 2020, stabbing her 23 times with a kitchen knife. The crime shocked Melbourne, and while Seiko will spend at least 30 years in prison, his sentence angered Celeste's family and friends, who have to live with the horror of her murder for the rest of their lives. I'm Dan Mullins. This is Crime Insider's Judgment, a deep dive on a judge's final verdict of a crime and what transpired to incite that judgment. Celeste Manno, born in November 1996, was the daughter of Aggie De Muro and Tony Manno, with a younger brother, Alessandro, and an elder half-brother, Jaden. She lived with her mother and brother in Mernda in outer Melbourne and worked as a respected team leader at the Serco call centre in Mill Park for 2.5 years. At Serco, she began a relationship with a co-worker, Christopher, which they kept private until Christopher left Serco in September 2020. Seiko, who commenced employment at Serco in April 2018, met Celeste when she became his team leader. His employment was terminated in June 2019 due to performance issues, and Celeste escorted him out of the workplace. As they exited, Seiko kissed Celeste on the cheek without her consent, an action that shocked her and marked the beginning of his obsession. Celeste did not reciprocate his feelings, but Seiko persisted in pursuing her through social media and other means. Following his termination, Seiko tracked Celeste's social media accounts, particularly Instagram, and began sending her direct messages expressing his feelings. Despite Celeste's polite rejections and eventual blocking of his accounts, Seiko created multiple new Instagram accounts to continue messaging her, declaring his love and ignoring her requests to stop. By December 2019, the messages became sexually explicit and derogatory, causing Celeste to fear for her safety. She reported his behaviour to her colleagues and observed Seiko watching her from his car outside Serco's offices. On July 1st, 2020, Celeste and her mother Aggie reported Seiko's stalking to Mernda police station, providing evidence of his persistent messages. On July 3, Celeste obtained an interim Personal Safety Intervention Order, or PSIO, against Seiko at the Heidelberg Magistrates Court, which was served on him on July 8. Initially, this halted his contact, but on August 4, Celeste sought to make the PSIO final. Seiko contested the order, and a hearing was scheduled for March 2021, some 7 months away. On August 10, Seiko was arrested and interviewed about his repeated messages. He admitted to creating multiple Instagram accounts to contact Celeste despite her objections, but denied the illegality of his actions, claiming the messages were therapeutic. On August 11, he purchased a kitchen knife from Woolworths, later used in the murder. On August 15, Seiko breached the PSIO by sending Celeste a letter via a Google Drive link, attempting to dissuade her from pursuing the PSIO and denying his wrongdoing. Celeste reported the breach to police, leading to another interview on the 25th of August, where Seiko admitted the breach but deflected blame. Additional charges for stalking and PSI breaches were served on him in September and October 2020. On November 16, at approximately 3:22 a.m, Seiko left his home in Roxburgh Park, driving to Celeste's home in Mernda. He parked his car nearby at 3:48 a.m, carrying a hammer and the kitchen knife. Seiko scaled a side fence, accessed the backyard, and used the hammer to smash Celeste's bedroom window through which he entered. Celeste was attacked with the knife, sustaining multiple sharp force injuries, including a fatal stab wound to the heart. Forensic pathologist Dr. Paul Bedford identified 23 sharp force injuries with defensive wounds on Celeste's forearms and hands. Seiko dropped the knife in the bedroom and the hammer in the yard, sustaining lacerations to his right hand that left a blood trail. He exited through the window, scaled the fence and returned to his car within 2 minutes and 39 seconds, as captured by CCTV. En route to Mernda police station, he discarded his Optus mobile phone in local parkland. That phone contained evidence of his communications with Celeste. At 3:57 a.m, Seiko arrived at the police station, his car colliding with a bollard. He made disjointed statements including, she's dead," and references to Celeste's address and a constable vandalist who had handled the PSIO matter. Seiko requested police to shoot him, but provided no further details about his actions. Meanwhile, Aggie, Celeste's mother, awakened by the sound of breaking glass, found Celeste covered in blood. She attempted CPR and called 000 at 3:56 a.m. Police and paramedics arrived, declaring Celeste dead at the scene. Seiko was arrested, treated for his hand injuries at St. Vincent's Hospital, and interviewed by Homicide Squad police. He admitted to locating Celeste's address via social media and Google Maps, driving past her house previously, and entering her bedroom with a hammer on the night of the murder. However, he claimed his memory was fuzzy and deflected responsibility, blaming law enforcement and external pressures. Police investigations confirmed Seiko's involvement. Bloodstains and exhibits were collected from Celeste's home and the surrounding area. DNA on the knife and hammer handles, as well as Celeste's fingernail scrapings, pointed strongly to Seiko as the murderer. The discarded Optus mobile phone, recovered on November 20, contained evidence of Seiko's persistent attempts to contact Celeste. A search of Seiko's bedroom yielded his computer and documents related to the PSIO proceedings. So who is Louis Seiko? He was born in 1985 in northern Iraq, migrated to Australia in 1992 at age 7 as part of a Chaldean Christian family fleeing religious persecution. His early childhood was traumatic, marked by his father's military service and time in a Turkish refugee camp. Raised in Roxburgh Park, Seiko was the eldest of 5 siblings, maintaining good family relationships. However, he struggled socially, experiencing bullying and difficulty fitting in, particularly during secondary and tertiary education. He excelled in mathematics, but dropped out of university science courses due to being socially ostracized. Seiko's adult life was characterized by isolation, unemployment, and mental health issues. He worked from time to time in retail, but was unemployed and receiving Centrelink benefits at the time of the offence. He had no prior criminal history, substance abuse, or violent behaviour. Diagnosed with body dysmorphic disorder, Seiko underwent rhinoplasty and used supplements to address perceived physical flaws. He experienced episodes of major depressive disorder and suicidal ideation, particularly in 2020, exacerbated by COVID-19 lockdowns and police interventions related to the PSIO. Forensic psychiatrist Dr. Rajan Darji diagnosed Seiko with an extreme personality disorder encompassing paranoid, schizoid, schizotypal, and anxious avoidant traits, resulting in severe psychological and social dysfunction. Dr. Darji suggested the personality disorder, combined with moderate to severe major depressive disorder, significantly impaired Seiko's judgment, contributing to his stalking and the murder. Dr. Darji noted that while these conditions were necessary for the offence, they were not sufficient alone, with external triggers playing a role. And he referred to things such as Celeste's relationship with her new boyfriend, Christopher, and her Instagram posts. Justice Jane Dixon said, "I note that in terms of any acceptance of responsibility close in time to the offence, you did make admissions linking yourself to the crime when you surrendered yourself to police and asked them to shoot you. Later in your record of interview, your answers contained a mix of partial admissions and denials or deflections of responsibility. You also concealed the existence of the Optus phone. I am satisfied that at that time you significantly downplayed aspects of your offending, as is clear from my earlier reference to your police interview. You have continued to make a range of spurious and absurd statements since then, including to Dr. Darji. Dr. Darji's evidence is relevant when considering your police interview after the offence and your behaviour since. He agreed that you can demonstrate an obsessional focus on minutiae or small details or ideas. One such example was your fixation with the number of wounds sustained by Celeste and your views as to what caused them. In his opinion, your attempt to downplay the number of knife wounds you inflicted was linked to your desire to avoid being seen as having committed a monstrous crime, and also linked to your difficulty in seeing things from the perspective of others. Dr. Darji said that in his opinion it would be too simple to boil down your response to your offending as being based on whether you were remorseful or not, or the degree of remorse shown. Under cross-examination by Mr. Patrick Burke, KC, for the prosecution, Dr. Darji maintained that whether or not someone is remorseful is not relevant to the potential risk of them doing something again, based on research and practice known to him. In his view, you appeared to not really understand the impact of what you did, and you tended to deny aspects of what happened. Dr. Darji also addressed aspects of your behaviour since your arrest, which were suggestive of you exaggerating or feigning symptoms, noting the complexity of motivations for this behaviour. He accepted that you sought a third consultation with him in the context of hoping to enliven a mental impairment defence, although your desire to be found not guilty by reason of mental impairment was not merely a straightforward attempt to get off, but rather was fueled by a complex combination of issues. Despite Dr. Darji's opinions concerning remorse, the Crown submitted that your lack of remorse or insight significantly negatived your prospects for rehabilitation and increased your risk to the community. Mr. Burke submitted that the court should view your prospects of rehabilitation as very poor and urged the need for increased emphasis on specific deterrence and community protection. Coming up, what happened in the wake of Seiko's arrest. Following his arrest on the 16th of November 2020, Seiko was charged with murder and remained in custody. The case faced delays due to assessments of his fitness to stand trial. Initial hearings occurred in the Melbourne Magistrates Court with a straight hand-up brief in September 21, bypassing a committal hearing. In February 2022, Associate Professor Andrew Carroll, a forensic psychiatrist, deemed Seiko unfit to stand trial, prompting further assessments by Dr. Claire McInerney and Professor James Ogloff. By February 2023, updated reports confirmed Seiko's fitness to stand trial, and he pleaded guilty to murder on the 6th of April 2023. The plea hearing, initially scheduled for July 2023, was delayed due to changes in Seiko's legal representation and a brief period where he was representing himself. Seiko contested aspects of the prosecution's case, particularly the number of sharp force injuries. Representing himself, he tried to convince the court the injuries were caused by glass shards from the broken window. You'll remember he pleaded guilty, suggesting he only stabbed Celeste twice. Seiko actually cross-examined forensic pathologist Paul Bedford, who argued in his opinion the wounds were knife wounds. Celeste's family walked out of the court in disgust. Victoria Legal Aid resumed representing Seiko, and the plea hearing occurred from the 29th to the 31st of January 2024. Seiko also argued and disputed the prosecution's claim that he ran to Celeste's house and the exact number of Instagram messages sent. These issues and disputes were resolved in favour of the prosecution's evidence, with the court finding them immaterial to the sentencing outcome. Victim impact statements from Celeste's family and friends were read during the plea hearing, highlighting the profound loss and trauma caused by her death. I'll read Aggie DeMoro's testimony. This is Celeste's mother. My sweetie was failed miserably. She was failed by a flawed system, the police, and she was failed by me. Finding myself face to face with the beast responsible for taking Celeste from me is one of the most confronting experiences I have ever had to deal with, other than the night he killed her. Aggie DeMoro then turned to Seiko. She said, "What did you achieve? Look at me. I hate you, and the only person I hate more than you is me. I couldn't protect her from you. You are a beast. You are an evil, repulsive, demonic beast." Celeste's father, Tony, broke down. He sobbed while telling the court Celeste was, quote, "the kindest, sweetest person you could ever meet." The family still visits Celeste's gravesite every month to pay their respects. Dr. Darji's evidence was pivotal, detailing Seiko's mental health and its impact on his culpability and future risk. The court deemed Seiko's offence a grave example of murder in the highest range of seriousness. Aggravating factors, which outline the various details of the offence which might indicate premeditation or impact the seriousness of the offence, included premeditation and planning. Seiko researched Celeste's address, drove past her house multiple times, and armed himself with a hammer and knife, indicating premeditated intent to kill. Another aggravating factor was the breach of the Personal Safety Intervention Order. The murder violated an interim PSIO, undermining legal protections intended to safeguard Celeste. Another factor was the cowardly execution. Seiko attacked Celeste in her bed at night, exploiting her vulnerability. And then the motive, driven by obsession, anger and jealousy, exacerbated by Celeste's relationship with Christopher and her pursuit of legal protection. There were also a number of what are called subjective factors, which are personal circumstances of the defendant, their age, their criminal history and mental state, that are taken into consideration by the judge during sentencing. Seiko's mental health significantly influenced the sentencing decisions. Dr. Darji's evidence supported the application of what are called Verdun's principles, which allow impaired mental functioning to mitigate sentencing in a number of ways. The court found one of those subjective factors was a reduced moral culpability. Seiko's extreme personality disorder and major depressive disorder impaired his judgment, reducing his moral culpability, though not to the extent of a mental impairment defense. Unlike psychotic conditions, Seiko could distinguish right from wrong, but his disorders narrowed his focus and disinhibited his behavior. Then there was the moderated deterrence. General and specific deterrents were moderated due to Seiko's impaired judgment, though not eliminated given the need for community protection. And then the burden of imprisonment. Seiko's mental health conditions made prison more burdensome, with a serious risk of adverse mental health effects, as evidenced by his suicidal ideation and isolation in custody. Seiko's guilty plea, entered on the 6th of April 2023, was not early due to delays from fitness assessments and changes in representation. The Crown argued the guilty plea warranted minimal weight, citing Seiko's lack of remorse and attempts to deflect responsibility. Seiko's police interview included partial admissions but minimised his actions, and he concealed the Optus phone. Dr. Darji suggested Seiko's lack of remorse stemmed from his personality disorder, which impaired his ability to understand the impact of his actions or empathise with others. The court recognised the utilitarian value of the guilty plea, sparing a trial and reducing distress to Celeste's family. Mitigation was also granted for harsher remand conditions during the COVID-19 pandemic, though this had less weight given Seiko's tendency to already self-isolate. Dr. Darji assessed Seiko's prospects for rehabilitation as limited due to the entrenched nature of his personality disorder, unlikely to attenuate significantly within a decade. Improvement, he said, depended on long-term psychiatric treatment and a secure environment. Without intervention, Seiko posed a moderate to high risk of future stalking and a high risk of serious violence if stalking resumed. However, with supervision and treatment, this risk could be managed. The Crown emphasised community protection, arguing Seiko's poor rehabilitation prospects and untreated personality disorder necessitated a severe sentence. The defence, citing the Director of Public Prosecutions versus Herman, argued that treatment availability was an executive responsibility, not a judicial one, and Seiko's rehabilitation prospects should be considered open, supporting a lengthy parole period for risk management. In sentencing, the court highlighted the following factors. There was objective gravity. The offence's premeditation, the breach of the PSIO, and execution placed it well above the standard sentence benchmark of 25 years. Then there was the mental health issue. Psychiatric principles reduced moral culpability and deterrence, but did not negate community protection needs. There was the guilty plea. The plea warranted modest mitigations for its utilitarian value, despite the absence of remorse. Then the court considered rehabilitation. Limited prospects were acknowledged, but treatment could improve outcomes over decades, supporting a parole period. Community protection. Seiko's risk profile necessitated a lengthy sentence balanced against the principle of parsimony. Then there was the victim impact. The profound loss to Celeste's family and community underscored the need for denunciation and punishment. The Crown cited the DPP versus Todd, where life imprisonment was imposed for a rape and murder driven by sexual sadism, arguing Seiko's case warranted similar severity. That case was where the Melbourne man James Todd stalked, raped and murdered Eurydice Dixon in a park in inner Melbourne in 2018. The defence distinguished Todd, noting Seiko's offence lacked sexual violence and his personality disorder was treatable, unlike Todd's untreatable disorder. The Crown also cited DPP versus Herman, involving a rape and murder with severe personality disorder, resulting in a 32-year sentence with a 25-year non-parole period. Cody Herman raped and murdered Arab-Israeli student Aya Musawir in 2019. The court was seeking precedent in sentencing Seiko based on previous judgments where mental impairment and mental illness had been a factor. The court sentenced Seiko to 36 years imprisonment with a 30-year non-parole period, declaring 1,200 days of pre-sentence detention. Had Seiko not pleaded guilty, the sentence would have been 40 years with a 36-year non-parole period. Justice Jane Dixon told the court, "Your rehabilitative prospects have already been referred to. You are now 39 and cannot rely on youthfulness to mitigate your offending, but given that your sentence will be measured in decades, you will be of very mature years before you could even be considered for release. I have accorded significant prominence to community protection because of the risks posed by you, whilst acknowledging that the courts have repeatedly warned of the difficulties of accurately making long-range predictions regarding future dangerousness. In announcing the non-parole period, it is well to keep in mind that the non-parole period is merely a direction as to the minimum term before a prisoner can even be considered for parole, and is not a separate sentence. In this case, the non-parole period will be fixed for a very long time in the future. By then, your prospects will be much clearer, and it will be a matter for the authorities as to whether you are capable of being released under supervision of parole. Your appalling crime is deserving of condign punishment, a punishment befitting the crime. Despite your plea of guilty, the sentence to be imposed must be of sufficient severity to uphold the sacrosanct value of human life and vindicate the rights of all persons to safety and security of person. Crimes such as this are profoundly disturbing to all who hear about them and must be firmly denounced. I have kept in mind the devastating impact of your offence on Celeste's family and friends. The object gravity of your offending is extremely high, but your psychiatric condition at the time of the offending reduces your moral culpability to some degree. General and specific deterrence, denunciation, and just punishment remain relevant in sentencing you. I am also cognizant of the principles of parsimony and proportionality. Luay Seiko, please stand. Luay Seiko, I sentence you to 36 years imprisonment. I fix a non-parole period of 30 years. Pursuant to Section 18 of the Sentencing Act, I declare that you have already served 1,200 days by way of pre-sentence detention, not including today's date, and I direct that this be reckoned as time already served under the current sentence. Pursuant to Section 6 of the Sentencing Act, I declare that had you not pleaded guilty, I would have imposed a sentence of 40 years imprisonment with a non-parole period of 36 years. Celeste's mother, Aggie DeMoro, distraught at the leniency of the sentence, addressed the media outside the court.
It's outrageous, absolutely unbelievable that the court decided to grant him mercy even though he showed Celeste none. That little trust I had left in this system has been completely destroyed. I don't believe in parole. I don't believe in releasing murderers to murder again. These politicians are only interested in helping when they see numbers, nothing else. It's not their kids. They are well protected.
Celeste's family, to this day, continues to lobby politicians to legislate mandatory ankle bracelets in conjunction with the issuing of protection orders and harsher penalties for those convicted of crimes such as Celeste's murder. They won't let Celeste's legacy fade. The judgment in the Victorian DPP vs. Louis Seiko balances the heinous nature of Celeste Manno's murder with Seiko's significant mental health impairments. The 36-year sentence, with a 30-year non-parole period, addresses the need for punishment, deterrence, and community protection, while acknowledging principles of sentencing orders suffering from mental illness and the utilitarian value of the guilty plea. The court's emphasis on long-term treatment and supervision reflects hope for rehabilitation, contingent on executive action, ensuring a just outcome that honours Celeste's memory and the profound loss to her family and community. Thanks for listening to Crime Insider's Judgments. We love hearing your feedback, so please rate and review this episode. If you have a case you want us to cover, let us know via Instagram at LiSTNR Crime or TikTok at LiSTNR Crime Team. I'll be back again next Thursday with another case. I'm Dan Mullins. Thanks for listening. This series was recorded and produced on Gadigal land.